The final federal law we're going to look at is the Archaeological Resources Protection Act of 1979. This is just called ARPA. This has been the most aggressive attempt we've had at the federal level to preserve archaeological resources. Congress enacted ARPA because antiquities, according to Diaz at least, contained unconstitutionally vague terms, so it wasn't effective in combating looting. Of course, we know that Diaz didn't apply to all of the states, but it still struck a blow for the power of the Antiquities Act. When the lawmakers and promoters for the act were working to create ARPA, they struggled to ensure through the legislative history and the statutory language that it was abundantly clear what was going to be protected. This doesn't mean the law escaped judicial challenge. Just very quickly, looking at ARPA and what it accomplishes, this is the replacement of the permitting procedures from the Antiquities Act and the standardization of this permitting process for all of the federal land managing agencies that are involved. It also establishes far more stringent criminal sanctions for resource crimes, and it adds civil enforcement and forfeiture provisions. Finally, it articulates the public's role in managing these resources. ARPA was introduced to the House of Representatives in February 1979 and in the Senate at the end of the same month. There was a strong cross-party support for the act, which people initially believed would ensure swift passage. The problem became hesitation based on the concerns of rock hunting clubs and metal detector manufacturers, who were concerned that the law would infringe on their activities. And the senators from Alaska, who were still cringing from Carter's proclamation of national monuments in '78, had stripped them of 56 million acres of federal land, wanted to use ARPA to weaken the Antiquities Act. So by the time it was passed, the law contained a lot of compromises that would affect rock, coin, bullet, and arrowhead collectors, which was quite the pastime in the 1970s. Fortunately, despite the desire of some politicians, ARPA didn't touch the National Monument Designations provisions from antiquities. Almost as soon as ARPA was passed on October 31st, 1979, the process of creating regulations began. Criminal prosecutions under ARPA could begin immediately after the passage of the Act, but none of the civil enforcement provisions could begin until the regulations were finished. Unfortunately, this took 4 years to complete. This is likely because the Department of the Interior, Agriculture, and Defense and the Tennessee Valley Authority were responsible for creating these regulations, with the Department of Interior being the lead agency. After a great deal of agency and public input, the regulations were published on January 6, 1984. Now please take a few minutes to read the law.